I'm Angelina Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. I wanted to first summarize for you what this measure is intending to do, specifically with our survivors of domestic violence, sexual assault, and stalking, which are all forms of intimate partner violence. What this measure is attempting to address is what is actually already happening in our courts, not here, but in other courts across the country, and also follow along the legislation which other states have passed. There are a total of 5 states that have passed some form of abusive litigation legislation, and it's to address the weaponization of our judicial system by former, or actually still probably concurrent in some instances, abusive partners for these survivors. We'll see that this has a detrimental impact on survivors of domestic violence, stalking, and sexual assault who thought that the abuse was over. This leads to additional emotional abuse. What the party is intending to do is constantly bring this person back into court, back into contact with the abusive partner so they can see them. They have to be there next to them in proximity. Their family members have to be there. They have to be witness to their family members harassing them as well, exerting all of this, as well as making them incur additional court fees and attorney's fees. Most of these are civil lawsuits, and as Representative Ganadin pointed out, and us other members of the judiciary have pointed out, private attorneys are not at $90 an hour. So the impact on survivors who may have the money to do this is that they run out of money fast, or they go into debt, so bad they have to make a choice. I'm just gonna have to deal with this or give up and somehow still be in contact with my abusive partner. This has a profound economic impact on our community as well. Survivors are not able to go back into work. They have childcare costs, they have transportation costs as well. So what this bill addresses to do is also allow the courts to be able to award, if they find that the litigant before them is abusive, not only have pre-filing requirements for that person. So we're not saying you can't come to court. I'm not saying that you don't have the right to come to court, but if you've been deemed an abusive litigant, we're gonna review what that is. And if you've been found to have been an abusive litigant for that case right there, you're gonna pay transportation costs, attorney's fees, court fees, et cetera. So my proposed amendments addresses something that actually is occurring in our family courts. We want to make sure that the respondent has been found an abuser of domestic violence, for instance, but what we're finding is that, especially at the advice of an attorney, a respondent will just agree to the protection order, even though, so there will be granted a protection order, permanent protection order, without a finding of domestic abuse. And we can look at a lot of cases recently in the news where if we looked hard at those protection orders, there weren't findings of domestic abuse, but they agreed to the protection order. So those are the first 3 amendments. We also want to make sure that all the charges of stalking are included therein. And I think you have it all in front of me. If you have any other questions, I'm happy to address them. You know where I sit.
Great, thank you very much.